Welcome, friends, for this part 6 of AEFC. Argue in English fluently and confidently. Friends, till date, we have covered 5 parts. And in last part, we have seen how we draft Gita's case. In detail, I have already shown you that particular case. I have given you in WhatsApp group also. And we will discuss all throughout the case with proper its annexures, everything, full bunch you have. That case is depend upon the suspension of the sentences given by accused. And we are on behalf of victim Gita in Supreme Court. Today, we will discuss how we argue that case and get it admitted, noticed by the Supreme Court of India. We will see the notice order, everything. Then, today we will give you one more case. And one more case of Dr. Neely from USA. That is very interesting case. Justice D.Y. Chandrachud has given the very best judgment in that. But as usual, we will see that case High Court order first. We will see High Court order. We will guide to our client. Then we will take that case. Then we will draft that case. Then we will discuss the arguing point of that particular case. Then we will see the notice issue. Then after notice arguments, and then final order of Supreme Court that in that particular case, Dr. Neely case. So we will see that Dr. Neely case only High Court order today. We will read that, we will discuss that, and we will guide to the client how he will be relieved from, he will get the relief from Supreme Court of India. When we are able to convince the client that he will get relief by showing proper points, everything, then client is easily ready to give you the case, even though you are demanding higher fees. But if you are telling only false statements and you are telling him only false things, 100% you will get justice like that. So people are not foolish. People knows this lawyer is a liar. He wants only case. Anyway, he wants to grab the money. So money-minded lawyers are there in Apex Court everywhere. But we should be honest with our duty. We should tell the true fact. But there should be a practical balance. Don't tell only 10% chances of your case to get admitted in Supreme Court. Don't tell that. Even though he will not give the case. Tell him, even though chances are 10%, but tell him 90% I have guaranteed to admit this case in Supreme Court. And after getting admitted, then 99% guarantee that case will be in your favor. But 1% I have to leave in the hand of the justice. So keep that margin. Otherwise, he will get disturbed. Don't tell 200% success guarantee. Tell 200% I will put my full efforts. I will put my efforts 200%. But I cannot guarantee 100% because I am not a liar advocate. I don't want only case by speaking lie with anybody. So friends, such type of guidance we have to give to the client. Then after getting document, how we draft the case, and then how to argue that case. So drafting of case should be on the basis of 3 important significant points. first point. It should be perfectly helpful for admission hearing. Admission hearing, you have only 1 to 3 minutes. In that 1 to 3 minutes, you have to show only 1 or 2, 3 points, which are very relevant to your case. And when judges feel there is a point for consideration, they will issue notice. So in proper synopsis, in proper list of date, there should be a highlighted point which you can show perfectly. We will see that how to take that points, then how to argue that point. In Gita's case, we will see that today. We will see that. Second point important, after getting notice, after getting counter affidavit of respondent, after completing 2-3 registry dates, when both side documentation is completed, then registry will list that matter before the main bench. Then both advocates, admission hearing, you only one is there. But after notice hearing, both advocates you are there. So that hearing is very important. So your draft should be useful for admission hearing, should be perfectly useful for after notice hearing. So grounds in proper sequence, your case laws should be in proper sequence. So that will be helpful to you for admission case. Sorry, after notice argument. This is the second point. You have to keep in memory. I'm getting it done from my team of 12. Now more than 12 junior I have. So I'm getting this drafting done very rigorously. And third important point, after notice hearing, when judges decided to give the judgment in your or in respondent's favor, whatever it may be, positively we will think in our favor, in our client's favor. So they have to write the judgment. So your pleading, your drafting should be useful to the judges to write judgment sequentially properly. So your draft should be useful for admission hearing, should be useful for after notice hearing, should be useful for meanwhile all types of arguments, and should be useful for to judges to draft that case. Such a perfect draft should be there. So we'll see all these things. Before that, as usual, we will see some verbs, legal verbs, which I have shown that folder in part 1. Now, today, I will show you that folder again, and I will share you that again today. 100. See, this is your today's, Dr. Nili's order, Gita's final order, everything I will show. 100 English verbs. These are legal verbs, which I have searched for you. So, if you are seriously practice all my part 16, definitely you will become a lawyer like my guru Nani Palkhiwala. Definitely. practice all 16 part properly. Now we are in 6th part. So these are that 1000 verbs. Aba, abesh, abeshed, abashed, abet, abet, abated, abide, abide, abode, abode, absorb, absorb, absorbed, accept, accepted, accepted, accompany, accompanied, accompanied, age, 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 achieve, achieved, achieved, acquire, acquired, acquired, act, acted, acted, add, added, added, address, addressed, addressed, adjust, adjusted, adjusted, admire, 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 admit, admitted, admitted, advise, advised, advised, afford, afforded, afforded. So see the list. These are the 1000 verbs. Nowhere you will get these legal verbs. So practice it. Huh? Fixed, fixed, fixed. Peach, peach, peach. Flap, flap, flapped. Flash, flash, flashed. Plea, played, played. Flying, plung, plung. Float, floated, floated. Plop, plop, plop. Gang, ganged, ganged. Gain, gained, gained. Gasery, gainsaid, gainsaid, gainsaid. Gash, gashed, gashed. Gauge, gauged, gauged. Get, got, got. Give, gave, given. Some we will take from 500 onwards. Learned, learned, learned. Leave, left, left. Lead, lead, lead. Lent, lent, lent. Let, let. Lick, licked, licked. Lie, lay, lied. Lie, lied, lied. Lift, lift, lift. Light, lit, lit. Huh? These are the 1000 legal verbs which will be very useful for legal spoken English, for practicing. We'll see some verbs in 700 series. Rolled, rolled, rolled. Wrote, rotated, rotated. Rub, rubbed, rubbed. Ruled, ruled, ruled. This is only instruction video. So in this video, we are giving instruction to practice it. We are showing you some samples, but at home you have to practice and practice it rigorously. Run, ran, run. Rush, rashed, rashed. Sack, sacked, sacked. Now we will see some in 900. Tired, tired, tired. Tossed, tossed, tossed. Touch, touch, touch. Train, train, train. Trampled, trampled, trampled. Transport, transport, transport. Like that. Use these. Try to use a daily take 5 verbs and use in 12 sentences if you are really weak in English. Nobody is weak in English as a lawyer, but they don't have the practice of the tenses. So we are here to give you full practice of tenses. So my each and every part cover the tenses. So today also we will take one verb and then we will complete all 12 sentences. Withdraw, work, worship, worry, write, yarn, yield, zing, zoom. Verify. So we'll take the word verify. We'll take the word verify. And we'll complete these things. Okay, I am now closing this chart, and then with proper gesture, we will see the verify. See, verify, verified, verified, verifies, and verifying. These are the 5 forms, main 3 forms. Original form, past tense, and past participle, which we have to use in perfect tense. And when continuous tense is there, we have to use ing. So in perfect continuous tense, we have to use past participle, also have, had also, and ing, not past participle, but we have to use ing also. So we will take that. We are going to see verify verb. Now, present tense. Simple present tense. I verify, we verify, you verify, you verify. He verify, she verify, it verify, they verify. Continuous present tense. I am verifying. We are verifying. You are verifying. You are verifying. He is verifying. She is verifying. It is verifying. They are verifying. Present past tense. I have verified. We have verified. You have verified. You have verified. He has verified. She has verified. It has verified. They have verified. Then perfect continuous present tense. I have been verifying. We have been verifying. You have been verifying. You have been verifying. He has been verifying. She has been verifying. It has been verifying. And they have been verifying. Now, past tense. Simple past. I verified. We verified. You verified. You verified. He verified. She verified. It verified. They verified. This is simple past tense. Now, continuous past tense. I was verifying. We were verifying. You were verifying. You were verifying. He was verifying. She was verifying. It was verifying. And they were verifying. Then perfect past tense. Perfect past tense had. I had verified. We had you verified. You had verified. You had verified. He had verified. She had verified. It had verified. They had verified. Perfect continuous past tense. I had been verifying. We had been verifying. You had been verifying. You had been verifying. He had been verifying. She had been verifying. It had been verifying. They had been verifying. Now, future tense. Simple future. I will verify. We will verify. You will verify. You will verify. He will verify. She will verify. It will verify. They will verify. Continuous future tense. I will be verifying. We will be verifying. You will be verifying. You will be verifying. He will be verifying. She will be verifying. It will be verifying. They will be verifying. Perfect future tense. When action is getting completed. We will have been verifying. Sorry, I will have been verifying. We will have been verifying. You will have been verifying. You will have been verifying. She will has been verifying. He will has been verifying. it will has been verifying. They will have been verifying. So these are 12 tenses. One verb you are using, so use different verb, at least 5 daily. So 12, 12, 12. Initially, you see the chart properly, but don't use that chart in your memory. So I am not giving you the chart, that chart. I am showing you that. You write that. You prepare your chart. But after some time, don't use chart. Any verb you have practiced to use that. So that will be a very great. Then I will show you some vocabulary. See, I am giving this glossary common, which I have given in part 1. Again, I am giving here, and I am showing you that. You should not forget this. These are very great glossaries. Wealth of word, legal words. The common legal terms. Let me see whether it is shared or not. Yes, it is shared. So daily, at least 5 new words you should get. Affinity related to a marriage, family relation with families of spouse, affinity, affidavit, affident, affirm, allege, to assert a fact in a pleading, affidavit or testimony, that is allege. Alternate juror, amend means modify, change. Amicus curiae, amicus curiae. Amicus curiae, also some in our Supreme Court, some lawyer are uttering its pronunciation like amicus curiae. Some are pronouncing amicus curiae, but amicus curiae is more better. So that is a friend of court. A non-party to a proceeding whom the court permit to present his or her or its view. Who is not from petitioner side, who is not from defendant side, but for the help, court has appointed that particular person or particular lawyer as amicus curiae. And specifically, writ petition, later writ petition, this can be done by the court. So, in the constitutional benches also, when constitutional bench hearing is there, that time amicus curiae are, these people are doing as amicus curiae. Arbitration, that is private courts. Businessmen are always using arbitration. They don't feel they will get the justice in civil court. They will not get justice civil court. So any businessman, when he doing agreement to other businessman, always in that agreement, business agreement, when dispute arise, clause will be of arbitration there. So on arbitration, I have separate my separate one Nani Palki wala program is there. So you can see that everything is available on YouTube. Some secret videos are there, they are not available there, but which I'm using here, which I'm suggesting here, that videos are openly available. So you will find my 2-3 videos on arbitration matter like that. So argument, at issue, attachment, attestation, attorney of record, award, decision given by arbitrator, bail, bar. So read these. This is not so big, only small. You can use in vocabulary. And for vocabulary and for getting good mastery on English, you regularly watch some good video of judges, learned senior lawyers, learned solicitor generals, advocate general, attorney generals, videos, legal luminaries, those who have good accuracy in legal terms. So I'm providing you in every part such type of video. Today, I am providing you that video which delivered by my favorite judge, my hero judge of Supreme Court, Rohinton Nariman. Justice Rohinton Nariman has delivered 1 hour, more than 1 hour lecture in 16th Nani Palkiwala Memorial Lecture Series in Mumbai. Nani Palkiwala Foundation is there in Mumbai, and that foundation is celebrating Nani Palkiwala Day. On that day, different experts are coming and they are giving lectures on different subjects. And that subject is connected to Nani Palkiwala. If you remember, in last episode, I have given you direct Nani Palkiwala's original lecture in Madras meeting. So that is very, very nice. But what is the speciality of Nani Palkiwala? Speciality of Nani Palkiwala, he is using always very simple words. He don't like hard words in the legal language. Common people should understand that. So their language is very simple. So it is very effective. You can find it in that particular case, Keshwananda Bharati, and so many cases in which Nani Palkiwala had argued at that time. So there is very simple. I'm desiring to publish one book on Nani Palkiwala's arguments only. Only Nani Palkiwala's argument. I will publish one book, definitely. I'm praying to God, give me the strength to compile that book. I will not write that book. I will compile that book. I will take from different judgments Nani Palkiwala's speeches, and I will give that speeches, and then I will give the effect of that speeches. I will give the effect of judgment, everything, ratio descendi, which principle recovered from that particular, after that particular argument, after giving the judgment, which principle born in the history of our legal India. So, I am giving you today that one very good lecture of Rohinton Nariman. You will find very good English vocabulary. Regularly, I am appealing you in each and every part. When you hear that, you watch that lecture, you first watch it continuously. Just understand, get enjoyment in that lecture. Then you second, just go and stop play where you find a difficult word, because they are using perfect words. Yesterday, one program was there. I will share that video of that program in part 7, definitely part 7. What is the accuracy of Justice Bhuyan, Ujjan Bhuyan, new judge? 2 judges we welcomed yesterday in SCBA, our meeting. And how he delivered lecture, how he used the perfect word. In that full 2 hours or 2 hours full lecture, you will find so many good pieces of a speech. Chief Justice D.Y. Chandrachud's speech, Attorney General's speech, SCBA President's speech. My friend, SCBA President is my friend, Dr. Adish Agarwala. These speeches I am giving you to find out the right vocabulary. Make the list, make proper books. And one thing I am going to design for you, that is one test on each part. And if you clear that test with 60% marks, Then I will give you the certificate of the Argue in English course. Otherwise not. So I will give this task to my junior. He will see all parts. He will prepare questionnaires. 4 options will be there. You have to select any one option and you have completed that test. Part 1, Part 2, Part 3, Part 4, Part 5, Part 6, up to Part 16. And when you complete that and when you get the more than 60% marks in that particular total assignments altogether. Yeah. But if you are reading, if you are getting properly, you will get 100% mark. Because we are framing multiple choice questions, which is very easy to understand. And no boss will be there. We will send you that questionnaires. We will send you question paper. You have the folder. But to solve that question paper, you have to follow my video of that part and understand that properly, all the study material. That time you can able to write the answers of that question set. And then you will get 60% marks. Then you will get the certificate from me of excellent. Yeah. Because my motto is not to earn money in Argue in English course. My motto is to create a legendary advocates like Nani Palkhiwala in argument skills. So we should follow them. So let me share you the video of complete speech by I will not run full video here. See, here is Justice Nariman Rohinton. He is my favorite. He was my favorite judge. Now he is retired. This is Bombay stage of Nani Palkhiwala Foundation. This is the introduction of this program. Now see, my hero judge. Hear it properly. If you have less voice, increase your voice.
Apart from the executive, etc., etc. Now, the importance, therefore, of these 2 chapters, that one consists in goals of legislation, which is the end that is to be achieved, and the other is the means to attain.
See Justice Nariman's speaking style. See his actions. Justice Nariman was elevated from Supreme Court Bar Association directly as a Supreme Court judge. When he was elevated, his practice was at that time more than crores. But he accepted judgeship, come down his earning, but he have given a very fantastic judgment to our nations.
The preamble of our Constitution itself declared for the first time that we will be a sovereign, democratic republic. Now each word is pregnant. We are sovereign because we have just overthrown the sovereignty of a foreign power. We are democratic because for the first time, the universal adult franchise is there for persons who may vote in and vote out governments of their choice. The government of India in 1935 divided the country into provinces. This Chandrachud was equally a dissenting judge in Kesavananda. Said, how can you put these two people above the law? The equality principle is directly in fact. Again, one more aspect of the picture. So imagine 5 judges, 4 of whom were minority judges in Kesavananda, actually applied what Peter Conrad said.
See the hands, gesture, speaking style, pointing style. Friend, this my program is very, 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 very best program to become an excellent advocate. Condition is to follow part 1 to part 16 rigorously. At your leisure. When you will follow, you will become 100% good lawyer. Because I am not teaching you only arguing skill. I am teaching you how to read a high court judgment, how to analyze that, how to guide the client, then how to draft that case, then how to argue the case after notice argument, final arguments, final orders, and all type of cases we are covering in this 16-part series. So this is the one video. I will give one more video of mine today on Supreme Court rules and procedure. Let me share you that. Here is some video links. It is Jayprakash Somani webinar. This is open. It is openly available. So I am giving that link to you. How to remove it, how to stop, how to go back. Because I have to run that. Yes. Here is, yes, see.
Section 25 of Civil Procedure Code is there, under which transfer by Supreme Court provision is there. So transfer of cases is also there.
So I have already shown you the orders, everything of Supreme Court procedure rules here. Just my appearance is different in this video and this video. This video is, I have French cut, and this is now my cut is Nana cut. My boyfriend said, you are looking at Nana. Really, I am Nana. My daughter's daughter, I am Nana. So this is a Nana. These like impress you while speaking. Judges are giving respect to us, to our years. With the grace of God, I have very good face value in Supreme Court. With the grace of God. This is blessing of God and my Guru Nani Parshwala. So listen that Supreme Court. 2 things you will get at one place. You will get the good vocabulary also in my speech, and you will get Supreme Court rules knowledge. And after some part, I will share you some High Court's rules also. Specifically Delhi High Court rules, then Bombay High Court rules, and Kolkata High Court rules, Madras High Court rules. Some High Courts rule will also share you. Mainly all High Courts rules are little bit similar, but when you are practicing High Courts and Supreme Court, that time you should know that rules. So I will cover that rules also in this program. Now, we will see how to argue Gita's case, admission hearing. Let me share you that case. Already I have shared that case in part 5. Yes. This is order. Just a minute. This is order. Let me share you. Gita's final PDF. Because first we argue, then we will see the notice order. I have already explained you this case in detail last time. Now we have to argue. So arguments, admission hearings main point should be in synopsis. Okay. We have to show how High Court is wrong by giving the order of the suspension of the sentences. When punishment is of 10 years rigorous imprisonment and High Court is giving the suspension after only 4 years imprisonment, then our legal systems balance in our country will be imbalanced, Lordship. And same High Court have rejected his suspension 2 times earlier. And see the grievous injury victim Gita has suffered. Lordship, please go on page number so and so. So you have to read these proper, read the annexure, and first show that where you want that judge will focus properly. So I have shown that Gita's picture, hospital picture, her injury, grievous injury on her hand or on her head. And then I will show some points and some case laws. After that, after arguing only, Justice Dinesh Maheshwari was presiding judge. After arguing only 2 minutes, he accepted the case. So main argument points you will find in a synopsis. You have to take that argument point on paper. Let me tell you the day before yesterday's mental situation. One case have bothered me so much because that case is so very long. I will share you that case also in some part. Very long case from 1981 to 2023. 2 times, 3 times they are coming to High Court, going here, going there, going there. And such type of case in admission hearing, I have only 2-3 minutes. How to show that important point? So in such a big case, admission here is very difficult. But in a small case, like Gita's case, admission in hearing is very easy. So first show that point which give you the grievous injustice to your client. And show the question of laws if required. Question of laws is there. These are question of laws. These are the grounds. Earlier question of laws. Here a question of laws. So important question of law. Whether the Honorable High Court erred in suspending the remaining sentence of this respondent number 2, despite the fact that respondent number 2 attacked the petitioner Geeta with a sharp-edged axe, kulhadi, and gave 3 blows, 1 on head and 2 on right hand, out of which 1 vehemently. Then, whether the Honorable High Court erred in suspending the remaining sentence of respondent number 2, despite the fact that a team of neurosurgeons, 3 doctors, along with the orthosurgeon, operated Geeta, and 2 major surgeries with implants were done to save her life for head and right hand. Neurosurgeon Dr. Vikram Dua from ORG hospital had given opinion about Geeta's injury in head as dangerous to life. That a medical board of 3 doctors team from BK hospital was formed by police to take opinion of M. Ala. You don't get so much big time there in admission area. You have to show how serious this offense, how he getted the punishment, 3 punishment, concurrently he is suffering that sentences, but after only 4 year sentences, where High Court is giving the suspensions of the sentences, then what will be balance of our judicial system of law and order in our country, Lordship, in the state of Punjab and Haryana specifically, where already problems are there. Immediately notice issue. How that notice issue? Okay, let me show you. So these are the question of laws. Then these are the grounds. This is not a so big case. The day before yesterday, very bad case. But early in the morning, I pray to God, give me the strength to argue this case. And God has given me this strength to argue that. And then, Honorable Supreme Court passed a very decent order in that. Decent order. They have mentioned everything properly. So I'm get satisfied. Now, I will show you the order of Geeta after this argument. How I got the order. They see here Geeta's order. Huh? Let me share. Geeta's order. Yes, now it is in front of you. Item number 42, that time's item number, court number 6, section 2B, Supreme Court of India, record of proceedings, special leave petition, criminal diary number so and so. Arising out of impugned final judgment, that is High Court judgment. Geeta versus State of Haryana. Quorum of the judges, this case was decided, this notice issue order was passed on 21/2023. This petition was called for hearing today. Quorum of judges, Justice Mr. Dinesh Maheshwari and Justice Mr. Rushikesh Roy. Advocate for petitioner, Jayprakash Somani, Advocate Shobha Somani, Advocate Rajneesh Kumar, Shahista Alam, Mamta Rani, Nishant Verma, Aksana, Vivek Sharma is AOR in this. And see the order. Upon hearing the counsel, the court made the following order. Permission to file special leave petition is granted. Issue notice. So this is very, very satisfactory moment. In my court, you will not get satisfaction by money. You will get satisfaction by such type of orders. So for that, your case drafting should be very fantastic. So read the High Court order twice or thrice. Find out the point which are against us. Find the solution of that point. Then find the case laws related to that point. Then start the drafting. And then take the part in synopsis like that, some part, some question of laws, grounds, and with the structure. So that draft should be useful to arguing counsel in admission hearing. That draft should be useful to arguing counsel in after notice hearing. That draft should be useful to arguing counsel to mention all the facts and all the question of laws grounds in final argument, and that draft should be useful to judges to write the judgment also. So you will find all these things in each and every my draft. From 2018 to 2022, I filed more than 150 cases in Supreme Courts. Getting drafted, argued, everything. More than 400, 500 appearances are there. Maybe more than 600 appearances. I'm telling about only Supreme Court. Sometimes I'm arguing in NCLAT also, National Company Law Appellate Tribunal. Sometimes I'm arguing in High Court also. When our online system is there, I'm arguing anywhere. But I'm arguing there only. I'm not taking that case to file and everything. I'm taking only Supreme Court case for filing. And Bombay NCLAT or High Court case for filing. But other High Court, if you are giving me giving any advocate for argument, that time I can argue only. So for argument, reading that properly, draft, reading a lecture, the style of what the relief exactly your client wants. So all this point you should consider properly. Now, last part of today's instruction video is new case, Dr. Neely's case. Today we will see Dr. Neely's High Court order first, which is against Dr. Neely. What was this case? Everything you will reveal through High Court order. See. This case I got through one advocate of Bangalore advocate, Karnataka. I don't know. I don't remember exactly. Maybe Karnataka or maybe Andhra. Maybe from Andhra also. Warangal. Where is Warangal? Okay. Leave it. In the court of the first additional judge magistrate first class Warangal. This is Warangal court's order. The present petition is filed under section 239 of the Code of the Criminal Procedure. Herein refer to CRPC by the petitioner who is accused number 1 in the above case, praying this court to discharge. In trial court, you can find if case is bogus, if cases don't have the proper proofs, then you can find accused can find the section 239 application to discharge from this case. So he filed that. So order is that. Now, Dr. Nili, here is petitioner, but Dr. Nili is accused in the trial court. So discharge application is filed by Dr. Nili. The respondent is state and his wife. See the story, everything you will get here. It is submitted that petitioner A1 is husband of LW1 and their marriage was performed long ago, and later petitioner accused number 1 has approached Honorable High Court while criminal petitioner number 4152 of 2014 and said petition are disposed with the observation that if the parties have compromised the lease, they can do so before the trial court in accordance with law. As such, present petition came to file seeking to discharge petition in the present case. So, this petitioner have already done the agreement with his wife to get compromise. So compromise, after getting compromise agreement, when wife is again filing cases or that case is running, so that is illegal. So Dr. Neely has approached to High Court, and that High Court saw under Article 4, under Section 482, quashing by the High Court. But High Court has not used their power. High Court has taken the base. So go to trial court and show to trial court that you have the compromised it. You, as a High Court judge, you have already saying that compromise agreement is there, and after compromise and both are getting divorced from each other. One is living in USA, another is living in UK, or maybe in India. We don't know where she is living. Both are married, remarried again, both have the children, and even though a previous wife is filing the cases. So such type of case, High Court should quash. But High Court has not used power. So that case comes to again the trial court, and trial court is giving decision. On notice, the learned APP has filed her counter. It was submitted that as per the report lodged by LW Srimati Jaya Madhuri Kothukari, the petitioner A1 harassed her and demanded additional dowry. It is submitted that the present case investigation officer recorded the statement of the witnesses who happened so and so and so and so. So point number, you will get the detailed history here. Used this point number 2, result is dismissed. So trial court has dismissed this case. So against that High Court order and against this order, we file SLP here in Supreme Court. Now question is that after getting this order, I read some part first, some part there, then last part, this is dismissed. And when this case was through advocate, and that advocate I have given the time. I will read the case and I will study the document. Please call me morning 9 a.m. So that party was in USA. So USA's time is different. Night time was there. But at 9 a.m., my advocate has called that party. My advocate, that party, was on conference call, called me in Delhi, and then we will discuss. I told only 2-3 things. Don't worry. After compromise deed, no case can be put in any court. So this is a misuse of the judicial system, misuse of the law has done by that particular complainant. So this we will try to quash. So Dr. Neely told me, are you giving 100% guarantee, sir? No. No, doctor. Nobody can give you 100% guarantee. Judges will not give you the 100% guarantee till they study the case, they hear both the arguments like that. But I have 90% confidence to get this case admitted. And after getting admission, 99% guaranteed to take the result in our favor. I don't want to speak lie and grab this case. So 90% chances is there. Let me keep 10% in the hand of the justice. Whatever fees like that, everything we will discuss. Then fees is finalized. Then some part of fees I received. All documents of lower court, everything I received. Excellent draft was drafted by my drafting team with my proper instructions. We'll see that draft of Dr. Neely case. It is very interesting case. Very interesting, very in-depth, very interested. And I argue that case before Justice Chandrachud on first, I think 1.5 minute, after 1.5 minute, issue notice. Then after notice hearing everything, then final order is in our favor. Dr. Neely's favor. And some points are there against High Court also in that order. That means some slaps Supreme Court has put on High Court's face. Because High Court should use their mind. When documents are there, compromise are there, both are married, remarried, both are divorced, remarried, both are doctors. Only harassment to the husbands. There is one my book on the mental cruelty against husband. Supreme Court case laws on mental cruelty against husband. I authored that book. You will see this book on Amazon, Flipkart, Jayprakash Somani book. Just type that. You will find all my Supreme Court case law. If any lawyer only purchase my books, 300, 400, 200 rupees prices are there. And if you read that 21 cases which is given in that particular book, you will be master in that particular law. Definitely. So sometime I am getting knowledge from my books also. From my video also I am getting inspired. So friends, we have already discussed this. Then we get the study material, as a drafting material, everything. Then we draft this case. So entire draft we will learn in part 7. In part 7, I will give some videos, again good videos of legendary judges, legendary advocates. Find out the right words, find out the meaning, and try to use that words into your daily vocabulary. Your focus should not be to get money in legal practice. Your focus should be to argue confidently in favor of your client. to get justice, proper justice to your client. And your duty to support to the court to adjudicate that matter. So you are always amicus curiae of the court. So show them particular case, show your against point also, and show how that point have the solution with you, which are the against you, and explain properly with perfect case law. At least minimum 3 case laws you should give in your arguments. You should get ready. Admission hearing, don't require that. When judges get understand yes, there is a injustice in this, they will immediately issue the notice. But all the judgments, all these case laws are useful for after notice final hearing. So minimum 3 judgments should be there. Maximum you can join 5, 6, but don't join more. Don't confuse the judges. Your argument, your speaking, your draft should be in a proper way. That will give you proper justice. But what happened in my court? So when we are challenging High Court's order here, so we have to take all the points which High Court lawyer has taken in his petition. We cannot hide any point. So whether that point is required to that case or not, it is immaterial for us. We have to take that. So we are helpless sometime here. We have to take all that point, all these annexures. But we are taking cream from that particular draft, and then we design our synopsis like that. And then we design our admission hearing points. And then we elaborate that points properly with proper gesture, smiling face. But case is serious, don't smile there. But just when you stand before the court, just give a smile. Lordship. You can say good morning, Lordship. Good morning, my lord. Like. So this is the part 6. Very shortly, I will share you some study material, and tomorrow Pooja will share its video link also. Don't forget to practice past part also, to practice that past videos also, practice legendary advocates, judges video also, practice vocabulary, practice tenses. You definitely become a legendary advocate of our nation. Some of you may be judges also. If I got the privilege to argue before you as a lordship, that will be my very fine day. One my student of AEFC is now judge in Supreme Court, and I am arguing that such type of great chance. I'm praying to my God, give me this chance. So friends, thank you very much. I'm stopping here video.